Welcome back, or just welcome if you're new here. I'm Carmen. I'm an employment relations practitioner and also the director of Free Employment Relations. I've included a list of my credentials in the description below to give you some peace of mind around the content that I share. This topic is constructive dismissal. It's a term that you won't find in the Labor Relations Act, so let's get into what it means. If you're not going to find the term constructive dismissal in the Labor Relations Act, which by the way is the act where dismissals are detailed, then where are you going to find it? Now, although you're not going to find the actual term constructive dismissal in the Labor Relations Act, the Labor Relations Act does detail dismissals, and one of the types of dismissals is what we commonly refer to as a constructive dismissal. Now, Section 186 of the Labor Relations Act defines what dismissal is. Specifically in today's video, I'm going to be talking about 186E, which states, an employee terminated employment with or without notice because the employer made continued employment intolerable. The first important distinction here is to note that the employee, not the employer, terminated the employment relationship. So essentially the employee resigned. But for this to be considered a dismissal rather than a resignation, the employee will need to prove that the employer made continued employment intolerable. If that is not proved, then it's simply a resignation. With other types of dismissal, if an employee alleges that it was an unfair dismissal and they take the case to the CCMA or the relevant bargaining council, when they get there, they're alleging that the dismissal was unfair, then the employer needs to prove that it was both procedurally and substantively fair. However, in constructive dismissal, that's different. If an employee is alleging constructive dismissal, then if they take it to the CCMA or relevant bargaining council, then the employee must prove that it was in fact a constructive dismissal. The reason why the onus is on an employee rather than the employer for constructive or alleged constructive dismissal cases is because in an ordinary dismissal case, if it is alleged that the dismissal is unfair and the parties go to the CCMA, it is accepted that there was a dismissal. So the onus is just on the employer to prove that the dismissal was in actual fact fair. But if there's a dispute, if the parties don't actually agree that there was a dismissal, then firstly the employee would need to prove that there was in fact a dismissal. And that's why with constructive dismissal, the point is to prove that it's not a resignation, that it is in fact constructive dismissal, and therefore the first point to prove is that a dismissal took place. And then the fairness element will come thereafter. It's easier for me to say you rather than to continuously say employer-employee. So now I'm going to explain what an employee needs to prove at the CCMA if they are alleging constructive dismissal for it to be deemed a constructive dismissal. So when I say you, I'm referring to employees who are alleging constructive dismissal. What does an employee need to prove in order for a case to be deemed a constructive dismissal? I'm going to go through them one by one and explain the greater detail of what you need to know. First things first, you need to prove as the employee that you are the one who ended the relationship. You either handed in your formal resignation or you abandoned your post, but it was very clear that you were resigning. If we just look at the definition one more time, it says there that the employee terminated employment with or without notice. So that means, employees, that you can resign with or without notice. Commonly with alleged constructive dismissal cases, we do see that employees don't work out their notice period, but that is definitely not a requirement. This act specifically says it can be with or without notice. So employees, if you're watching this and you're planning on taking a case to the CCMA for constructive dismissal, the first piece of documentation or evidence that you would take with you is your written resignation. The basic conditions of employment states that the employment relationship needs to be terminated in writing by either party, and therefore I strongly advise that when you resign, you do so in writing and you take that resignation with you to the CCMA. Second thing that you need to prove if you're going to the CCMA to allege constructive dismissal is that the reason that you are resigning is because the employer made continued employment intolerable. There are a few things to unpack here, so I'm going to take them one at a time. The first thing is that needs to be the reason. The reason needs to be the employer made continued employment intolerable. I'm going to say that so many times in this video, you're going to know the definition of constructive dismissal by heart. But what we got to focus on here is that there needs to be no other ulterior motive for resigning. So for example, if you resign and you claim constructive dismissal and the matter goes to the CCMA. And at the CCMA, it comes out that prior to your resignation, you received a job offer from another company which you accepted. It will seem like the motivation for the resignation is to accept this alternative job offer, and that the reason is not, in fact, that the employer made continued employment intolerable. The emphasis is that had it not been for whatever action it is causing continued employment to be intolerable, you would have continued to work at the company indefinitely. So that was the first thing under proving that the reason for the resignation was due to the employer having made the employment relationship intolerable or continued employment intolerable. Now the second thing is that was it the employer that rendered it intolerable? That might sound strange, but I have had cases where on a subjective level we could all agree that the employment situation was intolerable for the employee. There had been things that happened that resulted in the employee really not feeling like they can continue employment there, and we could all agree that it was intolerable. But what we did not agree on was that it was the employer's behavior that rendered it intolerable. That means if the employment relationship is intolerable due to circumstances beyond the employer's control, then it won't be deemed a constructive dismissal. One example that comes to mind was there was an employee who was working and there was a violent act that happened at the workplace from members of the public, and the employee did receive counseling that was funded by the employer to assist them with the trauma that came from this violent act that had happened. But after that, the job that the employee was doing, there was always some level of risk. No matter how many safety precautions the employer would put in place, the inherent requirement of the job was just one that there was quite a high level of risk, and the employee genuinely felt that it was intolerable for them to continue to work. However, the employer had done what was reasonably expected from them to create a safe working environment and to give the employee assistance and accommodation after the incident had occurred. This is one example where an employee claimed constructive dismissal and it was unsuccessful because they could not prove that it was the employer that rendered the employment relationship intolerable. Another example that comes to mind is if colleagues or suppliers or clients or other stakeholders outside or inside the business are emotionally traumatizing a particular employee. If the employer doesn't know about it or doesn't find out about it in any way, and this employee resigns and claims constructive dismissal, their case will not be successful in the CCMA because the employer wasn't made aware of it in any way or could not reasonably be expected to have been aware of this behavior that was going on. So again, it might be happening in the company, and it might even be from employees or clients or as part of the job. But if the employer is not aware of it, they cannot be expected to rectify the situation. Those are just two examples of how a employment relationship can be intolerable, but it's not necessarily as a result of the employer's behavior. Coming now to the third thing to prove under that the reason for the dismissal was the employer rendered continued employment intolerable. And this one is very difficult, and even for the most experienced practitioners, it can often be a bit of a challenge. And that is proving that continued employment was in fact intolerable. Quoting John Grogan now, intolerable is a strong word. Many times in my career, I have had conversations with employees where I hear them out and my response to them is, I hear you. What you endured was terrible. What you had to go through sounds really horrible and it sounds really hard. But what it comes down to is whether you can prove that that is constructive dismissal. Feelings of a massive inconvenience or subjective feelings of it was horrible doesn't necessarily amount to intolerable. And you're going to ask me, okay, but what is intolerable? Now, if you're looking for hard and fast and clear-cut rules, you're unlikely to find many of those in the realm of labor. The reality is that we look at cases in totality. We have guiding principles, but each case needs to be taken on its merits. Each case needs to be looked at the totality of principles that were applied. So what I can offer you is guiding principles to help make that decision, but I can't offer you a clear this is intolerable, this is not intolerable. There isn't a quick test that you can apply. I'm going to do my best to give you the best understanding so that you can apply that to whatever situation you're in to evaluate whether or not it was intolerable. Now, the test is one that is subjective and kind of objective. The subjective part of it is that we really need to give consideration to the perspective of the employee at the time when they resigned. We need to have a hard look at the time when they tendered that resignation. What was their mindset? What were their beliefs about the continuation of the employment relationship? Did they genuinely believe that it was intolerable, that they couldn't continue at the time when they put the resignation in? That part is very subjective because we're trying to put ourselves in the shoes of somebody else and say, at that time, what were they believing about the employment relationship? But then the second part, which is a bit more of an objective part, rather than us just simply taking the word of an employee who says, yes, at the time I believed continued employment was intolerable. The second part of that is, was it reasonable for them to assume or to believe or have the perspective that continued employment was intolerable? And reasonableness speaks to us looking at the circumstances. What were the circumstances in which they found themselves? What were the different factors that were contributing either to them feeling that way or to somebody else looking at it and thinking, it's not reasonable for them to have thought that? We look at the factors and the circumstances around it, as well as what was the perspective of the person at the time when they said, I can't continue this employment relationship. Let me give you an example that I've seen many times in my career, and I'm hoping that by discussing it in this video, I can kind of put to bed some of the misperceptions around this one in particular for employee. This is the example. An employee gets issued with a notification to attend a disciplinary inquiry. Then leading up to the disciplinary inquiry, the employee resigns, goes to the CCMA, alleges constructive dismissal. Now, I can't even tell you how many times I've done this particular scenario. And what always comes out is we go to the CCMA and the employee says, I knew I was going to get fired. I knew they weren't going to give me a fair opportunity. And the question comes down to it is, how did you know this? And also, why not see it through, go through the whole thing, go through the hearing, and when you're done and you believe that it was unfair, why not then refer an unfair dismissal, because that's your recourse? Why preempt it? You don't know that it would have been unfair. I haven't come across a case where an employee could provide an explanation where it was reasonable to assume that they really knew with certainty that they were not going to be afforded a fair opportunity at the hearing. Even in cases where a manager has said to an employee, yeah, I'm going to fire you if I put you in that hearing and things like that, which is obviously not appropriate to say because you can't preempt an outcome prior to a hearing. But if you get to that hearing, you don't know whether the manager is the person making that decision, because often they'll say those things, but then there'll be an impartial chairperson or somebody else chairing it, and that manager isn't the person making the decision. So you can't preempt whether disciplinary action will be fair or not before the time. It is extremely unlikely that your claim of constructive dismissal will be successful if you resign prior to disciplinary action being taken against you, and your reason is that you knew you were going to get fired or you knew it was going to be unfair. See it through, and then if you believe after whatever has happened that it was unfair, then take the matter to the CCMA. I wouldn't recommend that you resign prior to sitting through a disciplinary hearing and then claiming constructive dismissal. Bringing that example back to what we spoke about, the first test of subjectivity. Now, on a subjective level, if you put yourself in the perspective of the employee, I can see that they were scared, that they were truly convinced that they were not going to get a fair opportunity. At a subjective level, we can understand what they were experiencing at that time. But if we look at it more objectively, and we look at the factors and the considerations around it, then it becomes quite clear that the best alternative to resignation would have been to see the disciplinary action through and then referred the matter to the CCMA. Because it's such a difficult one, I'm going to pack intolerability a little bit more, but there's another point that I just want to highlight that is a general guiding principle that employees are expected to prove if they take a constructive dismissal case to the CCMA, but please, there's more to it than just it. And that is that there was no reasonable alternative other than terminating the employment relationship. In the past, this used to be some kind of hard rule where if you could prove that there was any other avenue that an employee could have taken to remedy the situation, then it wasn't deemed constructive dismissal. And then this kind of hard rule, became a little bit more strict when, through various cases, the outcomes were not that there was no other alternative, but that there wasn't really another reasonable option that the employee could have taken. So essentially, it sounds like I'm saying the same thing, but it went from quite a strict, hard rule to looking at it and be like, but is it reasonable of us to have expected the employee to know about that avenue or to have taken that avenue? So it became a lot less strict. Now this ties into something very important that I wanted to discuss. Employment relations practitioners or labor relations practitioners, HR, IR, whatever you want to call them, there's often been this, again, it's a guiding principle, but not a rule, and people applied it as a rule. And that was to say that an employee needs to lodge a grievance prior to resigning and claiming constructive dismissal. So again, people used to use this as a hard rule. You have to lodge a grievance, otherwise you're going to be unsuccessful with claiming constructive dismissal. But this is not a hard rule. It is a guiding principle. Yes, in most cases, there will be an expectation on employees to lodge a grievance prior to claiming constructive dismissal, but not in all cases. Before I get to the not in all cases, I'm going to cover the scenarios where I think it is a reasonable assumption that an employee should have lodged a grievance prior to resigning to be successful in their claim of constructive dismissal. First one, and most common one that we see, taking a specific example, you made a mistake at work and your manager comes and they start shouting at you in front of everybody. Yes, this experience can be extremely humiliating. It can be extremely degrading. But if an employee takes straight from that scenario, resigns and claims constructive dismissal, my question would be, could we not have remedied this situation by going through a sort of conflict mediation or a grievance procedure or something? So that's one circumstance where I would recommend that an employee lodge a grievance prior to resigning. Now, a lot of the times when employees bring this particular scenario to me and I say, well, I think you should have lodged a grievance, they say, no, well, the company didn't have a grievance procedure. They don't have a grievance policy. A company doesn't need to have a grievance procedure or a policy for you to lodge a grievance. Grievance is a fancy word for formal complaint. I have created a template for employees or employers to use to lodge a proper grievance. You can use the link below, and for a small fee, you can download my template for a grievance/formal complaint. Let's quickly discuss what needs to go in a grievance. Number one is, who is your grievance against? Is it against a particular person, a colleague, a supplier, a client, or is it a group of people? But be specific, or at least try to narrow it down, put the person's name, or at least, the department, but really try to be specific. Who is your grievance against? Number two, try to define what it is that you are aggrieved or unhappy about, but really try to use language that describes it to somebody who was not there. What I often find in my line of work from both employers and employees, someone will phone me and say, oh, so-and-so was so rude, they were so disrespectful, can't believe they did this, etc., etc. And then they will explain this for maybe like 10, 15 minutes, and I'll be sitting there and going, I still have no idea what the person did. I completely hear that you found it to be disrespectful, you feel humiliated by what they had done, but I have no idea what they actually did. So use language where somebody who wasn't there is able to see and completely understand, not based on your subjective experience of it, but what happened. So you want to include there, on this day, at approximately this time, person A walked up to me after I had made this mistake, and they said, and then try to say in there almost verbatim what they said to you. Instead of saying, they were so rude, say, they raised their voice at me. They were using swear words. They said these 5 words to me. They said it in front of, and then you want to say witness A, witness B, witness C, and you want to put the names of the people. And I understand, because when you're feeling aggrieved, you really want to express what's going on for you. A lot of the grievances that I receive say, I felt so sad, I felt so humiliated, I was disgusted in his behavior. And that's fine, you can include how you feel, but in a grievance, somebody reading that needs to know what happened, not just how you feel. So the emphasis needs to be on what happened, and then you can add in, as a result of this that happened, these are the feelings that I had. But the first important thing is, what happened. Dates, times, names, things that you can see, words that you can remember. That's why you want to write it down as soon as it kind of happens or soon thereafter so that you don't forget. And then finally, I just think it would be a really good idea to put on there by which particular date you want the company to give you feedback, just so that you know, all right, I've asked them to give me feedback by Tuesday. If Tuesday comes and goes, I can assume that they are ignoring it. If they haven't even said to me, oh, listen, we're looking into it, we don't have feedback for you now. If you've lodged a formal complaint or a grievance, remember, you can use my template and also use the principles that I've given you in this video to write a proper grievance or formal complaint, and the company genuinely ignores you. So you do say, okay, please give me feedback by this day. And that day comes and goes. I'd actually recommend that you follow up one more time to say, listen, did you receive my grievance? I'd like to know, are you going to give me feedback? And then if they ignore that, then I think it would be safe to say, obviously depending on what happened, I don't know what happened, that you can resign and claim constructive dismissal. But I would recommend that there is this attempt from your side, the employee side, to follow up with the grievance to see, are they going to do anything about it? Do they not plan on doing anything about it? And is it a reasonable time frame that I've given them to do something about it? Another example that I often see go to the CCMA is where an employer makes a mistake on the payment. So an employee receives, people don't usually complain about receiving too much money, but an employee doesn't receive the right amount of commission or maybe the right amount of overtime, or Sunday times was calculated incorrectly. And then they resign and take it to the CCMA. Obviously, if you're thinking about this, there must have been other factors that contributed to that. I don't think a all-round happy employee has this scenario and then resigns. But to my mind, if you were to claim constructive dismissal simply because there was this one-time error and you made no attempt from your side to inform the employer to say, listen, you've calculated this incorrectly, can you please rectify that? I think you would have a hard time proving constructive dismissal. That is not to say it is fair of an employer to make a mistake, or it's not to say it's fair that a manager shouted at you or anything. Those are just examples of times where I think a formal complaint could very easily remedy the situation, or at least provide the employer with an opportunity to remedy the situation. Now I'm going to use some examples that, to my mind, I think an employee can claim constructive dismissal without lodging a formal grievance. And then I'm going to use the example of sexual harassment. Generally, when we speak about sexual harassment, the person needs to be aware that their behavior is unwanted. Now, how this plays out, person A tells person B, hey, do you want to go on a date with me? Person B says, no, this is not sexual harassment. However, person A says to person B, do you want to go on a date with me? Person B says, no, and please stop asking me. But then person A continues and continues and continues to ask them, then we're falling into the realm of sexual harassment. That to me is the same as the lodging a grievance. It's telling somebody, no, this behavior is not appropriate, I'd like you to stop. Or a formal complaint. Listen, this incident happened, I'd like it to stop, I don't want you to continue with it. Okay, so those are the examples that we just discussed where a possible grievance or formal complaint can put to bed the issue that you're having. Now, many, but not all, sexual harassment cases are defined by a repeat offense or by person B having told person A, listen, stop, I don't want you to do this and this. There are incidences where one single incident is enough and severe enough to deem it sexual harassment, which as a first offense, without any warnings, without any no, I don't want you to do this, without any kind of other steps being taken, employee straight to a hearing, and through the hearing they find that this one single incident was enough to warrant a dismissal. I'm sure without me needing to provide any details, you can picture which sexual harassment scenarios those would be. But in those cases, it would not be reasonable for us to expect the person on the receiving end of that behavior to have lodged a formal grievance or to have put in a complaint or said no several times to ask, oh, okay, but what did you do to prevent this? Because it is severe enough that a single incident renders it sexual harassment. Now, translating that to constructive dismissal. Yes, the general rule would be to lodge a complaint, to do something to try to get it to stop or to try to fix the situation other than resigning. However, there are also single incidences that can be severe enough that don't warrant you having to lodge a grievance or put in a formal complaint. And sexual harassment, being on the receiving end of extreme sexual harassment, can be one of them if it comes directly from the employer. Because if it comes directly from the employer, who do you lodge the grievance to? And if it is one of those that is in a single incident deemed to be severe enough, then to my mind, it would make complete sense that somebody would be successful in their claim to constructive dismissal without having to lodge a grievance. Again, I'm giving an example, but please remember that these are guiding principles. There are exceptions. There are certain cases where things would be done differently depending on those factors. So another exception to the general rule was always that there was this onus on employees to prove that there was no other alternative other than resignation. So when things happen, for example, something would happen where their terms and conditions were unilaterally changed, an employee resigns, goes to the CCMA, claims constructive dismissal. Then the question would be, but the CCMA has a referral avenue for unilateral changes to terms and conditions. Or another one where an employer breaches health and safety regulations and an employee resigns, goes to CCMA, claims constructive dismissal. Then the question becomes, why didn't you report it to Department of Labor prior to your resignation? Because there is recourse for if an employer is not abiding by the health and safety regulations. And you're also protected if you do report your employer for non-compliance. But in many cases, yes, the question will be, okay, but there are these alternative avenues that you can go to remedy this situation. In my opinion, similarly to the grievance principle, is practitioners used to say, okay, but if there was any other avenue, then it's not constructive dismissal. But in my experience, I've not found that to be the case. Things need to be taken on an individual basis and look at whether the principle can be applied. Was it reasonable to expect the person to know what their recourse was? Was it reasonable for them to go through that process and to be able to use those avenues? Did they have the resources, the capabilities? There's a lot of factors to consider. Please don't blanketly apply that because there were these alternative avenues, now it can't possibly be constructive dismissal. Because I've seen cases go through the CCMA. There were alternative avenues that an employee could have taken, and the commissioner found that it was not reasonable to expect them to take those avenues prior to resigning, and then found that it was in actual fact constructive dismissal. So remember, that's a guiding principle that yes, it can generally be expected that they should follow the other avenues, such as lodging an unfair labor practice allegation or unilateral change to terms and conditions or reporting it to Department of Labor, but it is not in all cases. There have been cases where even failure to pay remuneration have been deemed constructive dismissal. The question is really about how reasonable is this alternative given the perspective of the employee at the time of resignation. So a quick discussion on this, but last year in 2020, a judgment came out from the Labour Court which clearly indicated that a grievance does not need to be lodged in all cases prior to claiming dismissal. I'm going to link that below if you want to check out the case for yourself, because I'm not going to discuss the details of it. Now that case law might feel like something very new, but it will only feel like something very new if we take guiding principles and we apply them as steadfast rules, where they were always intended to be guiding principles and not steadfast rules. So prior to this having come out in 2020, I did numerous cases where I would discuss it with the commissioners. They weren't always seen through because a lot of cases settle, but we would talk about it, and there was always this understanding that it's not a given that a grievance needs to be lodged in all cases. Yes, generally it will be expected, but it is not a break to the case if the employee does not lodge. Now we also have case law on that point. Maybe for some it contributes to the confusion around what is the threshold for intolerance, but in my opinion, it reminds all of us that what we do in labor, that if something isn't specifically in the act, and there are a lot of things in labor that we take as general rules that are guiding principles with a lot of exceptions. And this, for me, this case is a reminder that we need to look at cases in their totality. We need to weigh up their individual factors and look at that specific employee's perspective, and was it reasonable of that employee in those circumstances, rather than having maybe an over-reliance on strict rules to apply. Same thing with the 48 hours notice prior to a disciplinary inquiry. A lot of people will say, but the labor law says you have to give 2 days notice. The labor law doesn't say that. It's a guiding principle. There are times where the expectation can be that the notice period can be shorter or longer. That is the guiding principle, but it is not a legislative hard requirement. Now, if you're watching this video and you're pretty frustrated because you really would have liked a more clear-cut explanation on what is the threshold for intolerance, I am really sorry that I can't provide that. However, I really do hope that my explanation gave you some things to consider in the particular scenarios that you are in to help you to decide whether it is or is not intolerable. Now, just speaking to employment relations or HR, industrial relations or labor relations practitioners watching this, I do understand that having clear rules or clear guidelines for things does maybe help make the job a little bit easier. But in this line of work, it does require you to look at the totality of things, to be able to narrow down on the nitty-gritty and the technicalities, but also zoom out and say, were the guiding principles abided by here? Look at the big picture and the small picture and all the different pieces of the puzzle and how they fit together. So yeah, it adds to the challenge of it for sure. But in my opinion, it also adds to the beauty of it. Before I wrap up constructive dismissal, I'd like to just remind you that this video is made for educational purposes. Take your case by case and research it, look into it, use the principles in this video to do your own research or speak to an expert if you need to. An incredible resource for people working in the realm of labor relations, industrial relations, employment relations, or human resources, or just generally anything around this field is this book, because even though it was published a while ago, so still when I went over it prior to making this video and just reading it, the information in here has stood the test of time, because it provides, yes, it provides specific cases, but it does provide the general principle that needs to be applied when we're looking at scenarios. So wrapping up constructive dismissal. Constructive dismissal, unlike other types of dismissals where the employee terminates the employment relationship because the employer, not any other reason, made continued employment intolerable. So there should not be any ulterior motives. It is best to lodge a grievance if in circumstances you can lodge a grievance or look at alternative avenues to remedy the situation, but that is not a hard rule that needs to be applied in every circumstance. Remember to lodge a proper grievance if you really do want solutions to your problems, and you can use my template for that. I've also included a general constructive dismissal checklist, which again, you can't apply as a hard rule, but it might give you some guidance that every time you have this scenario, or if you're in this scenario, to go through those points and to give them consideration. Make sure that you don't miss giving considerations to the general important factors. And a reminder that intolerance, the threshold, is measured subjectively, meaning what was the perspective of the person when they resigned, and a bit more objectively, but still a little subjective, is the reasonableness thereof. So what are the contexts or the factors or the general circumstances around when the person resigned. And then a reminder to employees, it is deemed a resignation until you go all the way through the CCMA and prove that it was in fact a constructive dismissal. And remember, a resignation, you cannot claim UIF, but with a dismissal you can. So if you are claiming constructive dismissal, you needed to go all the way through the CCMA to be able to, on the UI-19 form, indicate that you were constructively dismissed. And that brings us to the end of today's video, everything that you need to know about constructive dismissal. I do hope that you have found this video helpful. Please remember to comment with any questions you have or any topics you want to see in future or things you want me to discuss in the upcoming weeks. I do put content out about employment relations or consulting or being a small business owner on a weekly basis. So if you want something addressed, please comment down below. And remember that it is very helpful for me to continue to bring you this content. If you like, subscribe, comment, and watch my videos. Thank you, and I will hopefully see you next week.